Bienvenue à la deuxième édition des procès fictifs en matière environnementale organisée dans le cadre de la Green Week. J'ai le plaisir de vous présenter le compte-rendu de l'activité de 3 universités, l'université d'Utrecht, l'université de Ghent et l'université catholique de Lyon, qui ont travaillé bien sûr en lien avec le thème de la Green Week de cette année.
Who worked on the topic of this year on a common case study. They dwelt on this case, and they submitted the case under Moot trials. The work was performed with the help of the law professors, but also with the help of specialized lawyers and judges specialized in the environmental field. And of course, the work of those students are being presented today to you. What about the claim itself? Well, it has to do, as I told you, to nature and biodiversity. The claim has to do with the granting of a permit to a farmer for expanding a pig farm. This pig farm is located near a Natura 2000 area, and the farm wishes to enlarge, to expand his farm to produce more pigs. Unfortunately, he is in a Natura 2000 area, which is highly sensitive to nitrogen load in terms of fertilizers. And of course, it resulted in a reaction, that is a claim by an NGO, considering that by granting this permit, there will be damages inflicted upon the neighboring Natura 2000 area, and more pigs should not be admitted in that farm as long as the critical nitrogen load is exceeded, which is the case for the time being. So the permit is challenged, and the permit was granted subject financial compensation by the farmer for upgrading the site. But it does not end there. To create sufficient space to expand his farm, our farmer would also like to demolish a crumbling barn, which is on his site, but unfortunately for him, in this barn you have a colony of common Pipistrella bats, which have settled there, which have been there for 2 years. And it is considered that this colony, the NGO considers that this colony should not only be displaced, but that the species should be protected. So that was, in a few words, the case submitted to those students. And of course, this is a fictitious case. It's a fictitious case, and the decisions, final decisions, are fictitious. Of course, the students were very lucky to work with their professors, but also with judges and specialized lawyers. Why such a fictitious trial? Well, because behind this you have an underlying question, namely a uniform interpretation of environmental law. We have standards, we have European standards which are translated into national laws. Is it easy or difficult to implement or to translate this community law into national laws? So we also asked our students to reflect upon basic concepts and basic principles of EU law, that is, supremacy of law, the guarantee of uniform interpretation by the European Court of Justice, the uniform interpretation by national judges, who are supposed to be guarantors of law compliance, and also standing, the interest to act. Beyond this, of course, efficacy of law in general. It was brilliant teamwork, a common project, a common European project, 3 universities coming together, and it was also an opportunity to put forward, to put at the forefront our law professors, our judges, our magistrates specialized in the field of environment, and also lawyers, and in general all law practitioners specialized in the field of environment, like people working for the Commission who together by the direction contribute to protecting nature and biodiversity.
More time on this. I would like just to now give the floor to those brilliant teams. I will begin with the University of Utrecht with Milton, followed by Hendrik and Shen for the Ghent University, and then Julia for the Université Catholique de Lyon. And I would like to ask them firstly, what are their general impression of this adventure? What are their main takeaways in doing this mock trial? This is really, by nature, a technical law. Working on environmental affairs brings you to very critical questions and scientific questions. And then the question for you is, what about the burden of proof? Was it so easy to handle? And do you consider that the judges should be specialized? So please, I give the floor first to Milton for the Utrecht University.
Yes, good afternoon, everyone, and thank you for this opportunity. To start with the first question, my main takeaway, I do think that the outcome of the case was satisfying. I consider this based on the fact that procedural law was correctly observed, and the substantive review of the claims was considered well according to relevant positive law. I don't know if I should go into all the questions that you ask.
How did you manage the burden of proof, for instance?
Yeah, okay. Yes. The burden of proof was clearly a challenge for the appellant, the NGO. But what we realized in doing this case was that it shifted because according to the law, the farmer who wanted to expand his farm, he first had a burden of proof to demonstrate that his activity would not impose a significant burden on the Natura 2000 site. And he did so with an assessment, an appropriate assessment. And based on this assessment, the NGO claimed that the findings of the assessment, that there would not be a significant effect on the site, that it didn't agree with that finding, but it was unable to provide counter evidence during the proceedings.
It seems that we've lost Milton.
Yes.
No, you're back, Milton.
Oh.
We can hear you, Milton.
Yeah. Yes? Okay. Yes, I don't know where I got disconnected.
That's the magic of digital. Please go on, feel free.
Yes. No, I mean where in my presentation or in my response I was disconnected, so that I can start from there again. Could you please help me with it?
Yeah, please go on.
Okay. So as I indicated, that the burden of proof was heavy for the appellant, the NGO, and that resulted in the case that the court upheld the decision made by the province to issue the permit to the farmer.
Okay, and just
Yes.
a last question for you. Do you have specialized court for environmental issues in the Netherlands?
No, we don't have a specialized court. It is the administrative court that deals with, are mostly the administrative court that deals with environmental claims because it relates directly to the decisions that are being made with respect to, for instance, permits, etc. But what we see is that lawyers are increasingly specializing in environmental law. So they are developing skills and knowledge in this area. And the courts, they rely on a foundation that a foundation of independent court experts in environmental and planning law that has the sole purpose to supply technical expertise to the administrative judges. This mechanism is quite unique in Europe, but it also holds some challenges such as cost and questions of the impartiality of the technical advice that's been provided to the judges.
Thank you, Milton. So now I give the floor to Hendrik and Sean for the Ghent University. So the same question applies to you, and I would particularly underline the element of the technical nature of environmental law and whether it's so easy, whether it's easier, to rely on threshold or limit value rather than concepts such as the impact on the environment and the likelihood of an environmental degradation. So what's your main takeaways? What about this technicality and also about the burden of proof? How did you manage this? Thanks. The floor is yours.
Thank you, Sarah. I will first give some main takeaways, and then Sean can add his personal reflections on learned from this moot court exercise. I have a slight echo when I speak. I don't know whether it's also the case with the other speakers. I just mentioned it. So first of all, I want to address that this moot court offers the university and the students the opportunity to jump from law in the books to law in the field, how EU environmental law is applied in practice. And I think this is an invaluable experience, both from the perspective of law professors as well as students. This is how we really learn how the law is working and tackling complex technical question that might arise when EU environmental law is applied in practice. So I think the case, first of all, was very relevant because we are witnessing a steady rise of lawsuits that are being submitted before administrative courts in Belgium, in which questions such as the effects of nitrogen depositions on Natura 2000 sites are deemed to be quite important in terms of the permit policy and the question whether or not additional permits can be granted. As far as the technical issues that pop up in this context are concerned, I think it's increasingly relevant also in the Belgian context. Judges are often confronted with technical reports. They have sometimes difficulties in addressing these questions. In sharp contrast to the Netherlands, we don't have any specialized instance which the administrative courts can rely in order to check the validity or the alleged flaws that are attached to environmental studies. So often courts they adjudicate cases, and when they adjudicate and dwell upon these cases, they themselves take into account main substantive questions that arise when dealing with these studies, and they also often rely on the precautionary principle. So to take this case as an example, it is the burden of proof is to some extent lies upon the applicant. So the environmental NGOs was required to submit at least some evidence that the additional addition could cause a significant effect on the Natura side. But the main takeaway is that it is up to the competent authority or the project developer to exclude any reasonable doubts in terms of significant effects here. So whenever there is an exceedance, it is up to the project developer to demonstrate that there is an absence of significant effects. And this is a very high threshold. So also in this case, the court ultimately ruled that mitigating measures that were presented, that there are no sufficient evidence that they create scientific certainty in terms of absence of significant effects. We do not have specialized courts for now, so such type of questions arise in front of administrative courts. They do have a certain familiarity with EU environmental law, but they are no technical. They are not technical experts. But possibly also John can add some additional elements from his perspective.
Yes, thank you, Hendrik.
The floor is yours.
Yeah, so just for context, I represented the team was representing the farmer and the authority that granted the permit. And then from this perspective, as Hendrik said, the burden of proof was a real challenge. It was really up to us to prove that there was, that it was really certain that there would be no harm in granting this permit to expand the pig farm. And we tried to be creative in all kinds of ways, but in the end, the court did not go along with our reasoning. And I think just from a lawyer's perspective, this makes a lot of sense. So insofar as there's a concern that the burden of proof would not be strong enough, also with concepts like which are not like targets, concrete targets, I think actually in the case of the Habitats Directive, the burden of proof is very strong when it comes at least to the question of compensating or restoring nature. So that's a key takeaway from the farmer's perspective.
Thank you very much. So, indeed, I mean, I'm not surprised that you face so much difficulties. It's not so easy to prove that the law is indeed breached. And that leads me to give the floor to University Catholic of Lyon. Julia, à vous la parole maintenant.
I give you the floor. What about your general experience and how did your case study evolve or develop? Did you also have some problems, some headaches with the issue of the burden of proof and technicality of environmental right? Thank you. Thank you very much, Clara, and good morning. Indeed, the decision by the judges was quite satisfactory. It should be pointed out that the judges decided to annul the authorization issued by the préfet due to considerations in connection with environmental incidents. The defendant did not produce an impact assessment, and they also said that such a case study was not necessary. Such an assessment was not necessary. I believe that there was some legal uncertainty between the European law, which is quite clear in that field, and the implementation and reception in national normative frameworks. There is a complex issue as far as we are concerned, something which is quite unclear in French legislation. namely the level of leeway for the préfet, which is the authority in charge, from the point of view of the impact assessment. Indeed, according to the European directive, any project that can have a significant effect on a site must be subject to an appropriate assessment. But the national law that after transposition of European law disposes that the project should be subject to an assessment if it is comprised in lists. At the same time, Article L4144 bis of the Environmental Code adds that any project which is not included in those lists is subject to Natura 2000 assessment based on motivations provided by the administrative authority. Here, the defendant did not present the impact assessment. They just submitted a note, a declaration, or a simplified notice, if you like, that did not take into account, that did not include an impact assessment, and they stated that such an assessment was necessary. So, what is the headroom for the préfet? And we also wonder if this provision for an impact assessment is a possibility or an obligation. So there is a problem here from the point of view of préfet and public authorities which are in charge of issuing or not issuing permits. And the difficulty also to assess based on the criteria listed in L4144 bis of French Environmental Code. Do these provisions allow for all cases an impact assessment to be conducted? Is it compulsory, or do the préfet enjoy a certain level of flexibility? This is not easy. It is not easy to appreciate. The decision was made by the judges in continuity with the European law, that is, demanding an impact assessment. And the absence of a significant impact was not excluded. But we believe it would be also useful to provide for a circular with administrative instructions, providing indications to the préfet or national public authorities that would allow them to have clear rules in agreement, in compliance with EU law, and guaranteeing some legal certainty for all actors involved. Now, regarding specialization, of course, we don't have specialized courts in environmental matters. Some training has been launched. It began in 2018, training for judges and for judicial staff, same from a criminal viewpoint. And there might be in the future a university degree in that matter. Thank you, Julia. It shows that, of course, this was it was a fictitious trial and the decision was fictitious. But all this shows that we have a European rule, and from that viewpoint, the EU jurisprudence is essential. It is there, but the real problem is a translation into national laws. And here again, the law must be clear. The rule must be clear. And as law practitioners, we must be extremely vigilant and extremely well informed as to the evolution of European environmental law, of European environmental jurisprudence. And I would like to say that for France, for instance, it was particularly interesting to note that the permit got annulled. And what you told us shows that there are indeed questions, and in that respect, the judge's role becomes fundamental. Thank you very much.
And checking also the chat, because if you want in the audience to raise questions, you may do it by clicking on the button with the question mark, and then we will have access to your question. The second is linked to the very nature of complaints in EU environmental law. It happens that there may be a bit abuses, what we call the NIMBY cases, not in my backyard. Here we have NGOs who wanted who contested the permit, and with regard to these trends to abuse and use environmental legislation just to oppose to a project that people dislike, what do you think of it? Do you consider that we should have a broad access to justice, or on the contrary, that it should be curtailed so as to be restricted in bringing cases? So it relates to, of course, to the legal standing of NGO as well. If we have seen with the case, and by the way, the documentation will be put online later on for those interested, that depending on Utrecht University or Ghent University, admissibility was treated a bit differently. So what do you think? Does it enrich your practice that NGO do have more access rights, wider access rights, and if so, yes. And then I would give first the floor to the Ghent University for Henrik and Sean. The floor is yours, and you'll be followed by Camille for Lyon University and Luce for the Utrecht University. But first, Henrik and Sean. Thanks.
Thank you. I think when it comes to the topic of standing, I still hear echo when I talk, so that's a brief reminder. So in terms of standing and public interest litigation, we accepted the standing of the environmental NGO in this case. This should not come as a surprise when approached in the context of recent case law developments in Belgium. Indeed, until the turn of the 21st century, environmental proceedings were a rarity. The prevailing attitude amongst judges, including the Cour de Cassation, was to dismiss such cases since they amounted to actio popularis. But with the implementation and the ratification of the Aarhus Convention, as well as the EU environmental directives, for instance, the EIA directive, this restrictive approach was replaced by a more progressive attitude. So in terms of administrative case law, the administrative courts mostly now accept the standing of environmental NGOs in such type of cases. And also it is important to underline that the Cour de Cassation has reversed its traditional, rather restrictive approach and has accepted the relevance of Article 9 of the Aarhus Convention when interpreting national procedural laws in terms of standing. When it comes, of course, this more progressive case law is contested from the side of project developers. There are indeed tendencies also in Parliament to curtail access to justice by modifying existing legislation. For instance, there was one, and this is quite interesting since I think it's also the case in the Netherlands and in other countries, there was one attempt to limit access to justice to those NGOs and to this part of the public that already participated in the participation procedure prior to the issuance of the permits. So this condition, this additional condition and additional restriction was quashed by the Constitutional Court with reference to the Aarhus Convention. So this as a major backdrop to the outcome of also the case that was at hand in the context of the Moot Court exercise. But I think there was an interesting topic that emerged when touching upon standing in the specific context of this fictitious case, and Sean will further elaborate on that because I think it's quite interesting.
Thank you. So, Sean, it's your turn.
Sean, the floor is yours.
Sean, we cannot hear you. Maybe you mute.
Yes, Sean, I briefly. Yes, Sean, I gave you the floor in order to elaborate on the specific of the standing issues to be treated in our Moot Court exercise. It was a very compelling issue that had to be addressed.
So what was interesting in our case actually was that there were two NGOs involved. So on the one hand, there was the applicant NGO, Red Antwerpse Kempen, who complained about the local farmer's permit to expand the pig farm on the condition that he contributes to restoring the site. But on the other hand, there was another Flemish NGO, Natura, who was the owner of the protected area concerned, and therefore the stakeholder that has a direct individual concern in it, the farmer argued. According to the Belgian Council of State case law, an applicant association can defend a public interest as long as it is possible to reasonably assume that the association's position on the public interest is sufficiently representative. In particular, that position must coincide with those of the stakeholders that have a direct and individual concern themselves. In this case, the owner of the protected area, Natura, did support the planned restoration works of the farmer in order to compensate for the nitrogen deposition that was already affected in the area. Thus, the farmer pointed out that the position of the applicant conflicts with that of the owner of the property of the site, Natura. Considering this, the farmer could argue that the applicant NGO was inadmissible, as his position on the public interest did not actually coincide with that of the main stakeholder, Natura. So in short, I think the applicant NGO might be inadmissible in another case or context, even though the court did not go with this argument in the end. And perhaps this is also of relevance in other member states.
Yeah,
as a last remark, I can briefly clarify that we did not agree with this argumentation because it offers the opportunity to project developers to block cases simply by collaborating with other NGOs, and thereby they would block access to justice in the context of their permit application. So it might be a strategy to immunize permit decision by simply collaborating with other NGOs. So this is the reason why we ultimately decided to grant standing to the NGO.
Thank you very much. That's really interesting to hear you. So you see that there should be some limits to avoid problems. Camille, pour vous, vous avez...
In Lyon, you annulled the permit, but did you have the opportunity to dwell on that issue that is standing, NGOs standing, and how did you understand it? Yes, regarding the fictitious trial in France, the question of NGOs standing was not an obstacle. It was not dealt with in our submissions. Since the law of 1901, any legal person can go to court. The association can be there as a plaintiff or as a defendant. But a number of conditions must be filled at the time the complaint is introduced. The association must have the capacity to act. The interest must be legitimate, concrete, direct, and personal. Regarding quality, the defense of collective rights by associations before administrative jurisdictions, as is the case here, was admitted by the Council of State in 1906, following the law adoption, and the association must have legal personality, and the action initiated must be within the framework of its social object, as enshrined in the statutes. the judge will focus on the social aim of the association. For instance, if an association is there to defend taxpayers, it will be assessed whether taxpayers are potentially affected by the project. And if the association states in its object, its purpose, that it defends environment or nature, that will be enough to recognize its standing as sufficiently direct. The only difference in terms of jurisprudence is that the purpose or the interest defended should not be too general. And there must be a sufficiently direct link with the decision at stake. For instance, an association for nature protection must exercise its action on a given territory. The French judge has a wide interpretation of these criteria. To defend the environment, the legislator recognizes certain associations the right to act or to go to court when nature is polluted, denatured, or simply threatened by certain abusive, irregular, or illegal decisions made by public decision makers. Here, these authorized associations don't even have to demonstrate that they fill the criteria above and can act everywhere throughout the territory. And finally, all these regulations make it possible for associations to go to court. Thank you, Camille. So this is pretty wide.
Utrecht University with Luz. Luz, I think that for your case, your NGO was protecting particularly the Natura 2000 area, isn't it? Can you tell us more about it?
Yes, thank you very much. So first of all, as to the first question you raised, I don't support the suggestion to impose access to justice barriers in response to addressing the presumed misuse of court procedures in not in my backyard procedures, because that would undermine the basic principle of rule of law and the principle of access to a competent, impartial, and independent court, because two opposing interests should have the opportunity to be brought before an independent court. And moreover, the adjudication based on applicable procedural law will determine standing, while substantive review will determine whether there is legal merit in the case or not. So in case of these unwanted, not in my backyard cases, the case could be admissible, but in the substantive review part, it will be determined, for example, that the case does not have sufficient legal grounds. So in our moot court at Utrecht University, the NGO did not have standing because it was determined that it was not an interested party according to its statutes. Because the statutes of the NGO stated that the goal of the NGO is to protect and preserve the Natura 2000 area, but the barn where the bats were living was located outside of this nature area. But what we discussed with the court after they gave their ruling is that if the court would have been less strict regarding the admissibility of the NGO, the decision to demolish the barn would have been unlawful, because destroying the barn would be a destruction of a resting place of a protected bats on which no derogation is possible. So this shows for me that the NGOs, it is important that NGOs have access to justice without very strict barriers. And also, if barriers are too strict, I think it might lead to individuals taking the law into their own hands. As regards the question of whether the involvement of NGOs enrich environmental law implementation processes, I would say definitely yes, because the involvement because NGOs, they often have more specialized knowledge in issues concerning the climate, more than, for example, private citizens have. And also the success rates of appeals of NGOs are generally very high. So it shows that the participation of NGOs is very useful to implement environmental law. And most importantly, I would say that NGOs kind of have this watchdog function where they monitor government compliance with environmental laws and regulations and policies, because the environment itself cannot go to court and appeal a case. We have the NGOs to voice their needs and go to court in name of the environment and protecting the environment. So the NGOs kind of provide for an extra check to make sure that environmental laws are not breached and that they are implemented in the right way. Thank you.
Thank you, Luz. Yes, indeed, we surely need them to protect nature too, and I'm sure that tomorrow we'll have other sessions where NGO will also indicate why it's important for them to play an active role into the protection of nature and biodiversity. And I'm thinking particularly of tomorrow's session at 9:30, Can Law Save Nature? Now I come to my last question, and I see also a question from the audience that's connected to this, a question from Bruno Botil. We saw in this case that Natura 2000 is not a system of strict nature reserves, if you wish. We are protecting the area, but you could have still project, construction, permits granted to build something in a Natura 2000 area, provided that it causes no significant harm to that area. So, to a certain extent, in this case, be it Mr. Janssens or Monsieur Patanegra, our farmer was limited in his option with regard to the development of his farm, and may have felt very much frustrated. We could imagine a real case. He would be frustrated, of course, not being able to expand his establishment. But is it then going beyond this fair to say to a farmer, a singled out farmer, you cannot do it, you cannot go ahead, and you cannot have more animals and pigs in your farm because you're already in an area that has reached its point of no return, or the limit value here with regard to nitrogen deposition. Should it be more flexible? Should we have another view angle? If I look at the question of Bruno Botil, here the question is also related to this. Shouldn't we protect it more, our Natura 2000 area, our protected area, and then just avoid any new development if it has an impact? And should we freeze any new development? Is it a good idea in your view? And an underlying question to you as well, which is a bit more technical, I would say. You recall that in the court case, the case submitted to you, we have this idea of our farmer paying an amount of money for ecological restoration of the site. Did you find it so easy to make a distinction between mitigation measures and compensation measures with regard to the implementation here of Article 6 of the Habitats Directive? So to answer to those delicate and numerous questions, I would give the floor first to you, Marc, for University of Lyon, followed by Chris Bakes for Utrecht University, and Hendrik for the Ghent University. Marc, la parole est pour toi.
Thank you. Just first reaction of the curve. Should any activity be banned on those sites, given the general degradation of biodiversity? I believe that the question needs to be reassessed each time based on potential impacts each project might have. each project, I believe, should be assessed, and it should be guaranteed that there will be no degradation. Now, the fact that we just get rid of a small farmer wanting to enlarge his farm, this is going to have a major economic impact on him, of course, I know. But if we want to settle the entire problem of biodiversity, we can't be stopped by such projects. It is a tough reality, but it is necessary, and I believe that our case study was a perfect illustration of such a situation. There was no impact assessment. The absence of an impact assessment resulted in the permit being annulled. I mean that the work was not done so as not to ensure that the impacts would be very limited. And this takes us back to the second question, namely, the very notion of compensation or of impact reduction. Are these notions sufficiently clear? I believe that one of the points which resulted in the lack of impact assessment was a confusion between the concept of reduction and the concept of compensation. For many project developers, the fact that compensations are proposed, including financial compensations, the project shall have no impact or will have no impact, which is false, of course. And for that reason, impact assessments are not made. And what is at stake here is the need for some clarification as to the fact that impact assessments are not options. An impact assessment is an obligation, including when you have just a slight doubt on potential impacts. The problem here for the developer was that he knew that there were going to be impacts, and he was proposing a compensation. But at the same time, he said that an assessment was not needed because there would be no impact. So there was some contradiction in his reasoning, and that contradiction was highlighted in the decision by the court. Thank you, Mark.
Would you like to take the floor and share your thought with us? We cannot hear you. Maybe you're muted.
To do it without headphones. Can you hear me now?
Yes, we do.
Yeah? We do. Okay, fine. Well, on the first question that you raised, I think it's a fair balance in the Habitats Directive. There are 2 or 3 general principles applying in such cases. It's the prevention principle, the polluter pays principle, and to a certain extent, the proportionality principle. And they are all enhanced in the legal structure of the Habitats Directive. If it concerns new activities, like this was the case here, it is necessary to have this test to see whether new activities can go through within the limits that the biodiversity gives us. So what the Habitat Directive does is not exclude all new activities, but set limits to these activities, because the main areas of biodiversity have to be protected. And I think that is a quite clear concept and a fair concept. And it doesn't matter whether it's a farm or industrial activity, it's all the same. They all have to run through the same test and prove that they do not harm the significant values of this Natura 2000 area. As regards your question of the difference between compensation on the one hand and mitigation on the other hand, well, we have a lot of guidance by the Commission, drafted by the Commission, and we have a lot of case law on this in the meantime. And what the case showed, that the Dutch students who hadn't dealt with this topic in their classes before were perfectly fine with finding the right legal qualifications and with making this difference. It may not be always applied correctly on the ground floor, and not in all cases, but I think that the administrative authorities and for sure the judges have very good guidelines to handle and to apply this difference. Well, the last question, whether a full stop of activities in situations where there's already an exceedance is a good idea. We have such a kind of lockdown in the Netherlands to far an extent. It's not very surprisingly, because we have the country with the highest nitrogen depositions in Europe. But I wonder whether this is the most efficient way to protect nature and to improve Natura 2000 areas. Because very often a renovation and reduction of existing, already long time existing polluters may be much more efficient than stopping all very, very little new activities which cause a very little extra new deposition. If you compare the practices in the EU countries like Germany, Denmark, Belgium, France, the Netherlands, you see that at this point there are huge differences. And some have such a blockade, such a lockdown, such no new activities if the threshold is exceeded, especially the Netherlands, and others do not do that. And I think if you compare the countries, the member states can learn a lot from each other. And I think that the best and most efficient solution in this question is somewhere in the happy medium of these countries. And as such an exercise as we did demonstrates on this point that the countries can learn a lot from each other's practice, from comparing each other's practice. And to my opinion, this should be done much more often. Thanks.
Thank you, Chris. Yes, indeed, we do have some tools for sharing among us the best practices on environmental implementation. So it gives me the occasion to inform those listening at us today that we have what we call the EIR, Environmental Implementation Review TIEX peer-to-peer exchange platform that helps national authorities on sharing new ideas, concept or way of doing and implementing environmental legislation and rules and standards the best possible way and face common issues that most member states know. And also with regard to the pure interpretation and the need for judges to be well aware of this, we have this program of cooperation with judges and to have, apart from the guidelines that the Commission has prepared and that Mark, you mentioned, the chance to practice together and to learn together. And then Hendrik, I think that because it's 12:54, you will have the occasion of having the closing words. What do you think? And also maybe you will touch upon the precautionary principle that you mentioned earlier here. I don't know, but what's your view on this with regard to Belgium?
I can echo the statements of Chris and Mark. I think Chris has aptly pointed out that there is no level playing field, that countries facing similar environmental conditions are treating EU environmental law in different manners, which leads to different outcomes. From my perspective, I would point out that the outcome of the case in Belgium is pretty straightforward. The Belgian Council of State has already ruled in the year 2000 that existing conservation efforts that are mandatory in order to improve the status of a degraded area are to be framed as additional conservation measures and cannot be double used as mitigation measures. And also in a similar context, the Council of State has already on numerous occasions concluded that the restoration of nature cannot be reframed as avoidance measures. I think when it comes to the issue of freezing additional or freezing the room for economic development, we are approaching a catch-22. I think from the perspective of a farmer, it can indeed be an obstacle, and it is very unfair. At the same time, the interests of farmers are being represented by lobbying groups that often also block additional efforts to come forward with more sector-based reduction actions, more sector-based restoration actions. So effectively, we are entering a vicious circle. It is indeed very complicated to issue additional permits when the room for development is exceeded, as was demonstrated in the case. Yet at the same time, lobby groups are very hesitant often when governments are proposing more far-reaching efforts in order to restore or to reduce additional pollution effects. So basically, I'm of the opinion that Article 6 is to be reframed as a due diligence obligation. Chris has also stressed it. It's basically very straightforward. And it also, we need to reiterate the ecosystem-based approach that is included in the Habitats Directive. Basically, it's not merely about species and specific habitats, but it's about the ecosystem. And you have certain boundaries. And when these boundaries are exceeded, it is only diligent of a competent authority to refuse to allow further degradations. I give also the floor to Sean to offer some final thoughts on that.
Sean, we cannot hear
your audio.
You're still muted.
Yeah, so very quickly, because I realize we're almost out of time. In our case, the ruling with regard to the protected bat species was that the barn could be demolished on the condition that the species could be safely moved according to the science. And obviously this is flexibility, which is useful for a farmer. And yeah, perhaps that's really good. But from an ecosystem perspective that Hendrik was just talking about, perhaps that's not so good because if you think about the potential consequences, it could mean that other projects could simply use a derogation that exists in the Habitats Directive to move a species for environmental reasons. But then that species might continue to be moved to places that are suboptimal for it. And then it might end up in an ecological trap, it's called, where it lives in suboptimal environmental conditions that do not allow it to, or reduce its chances to survive. And that might actually be counterproductive to the whole aim of the Habitats Directive.
Thank you very much. It's indeed very difficult to strike a balance between all those interests. The case was obviously on purpose provocative to go into a deeper discussion in these issues that are necessarily ending up in the desk of our judges in Europe. I have still 2 minutes to thank you very much all and give a chance for the audience. Oh, no, 1 minute left. So to give the audience a chance to raise the last question. But in any event, thank you very much. It's been a very interesting event, a very interesting adventure in itself to go through this case and work with you on the mock trials. For those interested, the documentation will be available on the site, clicking on the link of the session of today. If you want to go deeper into this and see in some kind of resume of the judgment and the cases made by each university. Who knows, maybe at the end of the process we will have a nice Green Week jurisprudence, well established and followed. Could be very interesting to see this happening, and most probably we will see all in the next Green Week session 2021. Thank you.
Thank you.